Both Ripple and SEC finally admit that Ripple owes no fiduciary duty to XRP holders in the continuing case. Therefore, the XRP army is all set to serve its own interests in the case. There is much more to this. Do you want to know more? Then keep watching this video till the end. But first, we are giving away 25 XRP coins at the end of the month to one random subscriber to start on their XRP journey. All you need to do is to like the video, subscribe and comment your thoughts on XRP in the comment section. Welcome, XRP Army. Let's grow the XRP Lab community by pressing the like button and subscribe. The United States Securities and Exchange Commission has registered its opposition to Ripple's motion to force it to answer how the Howey test was employed in virtually all of Ripple's transactions in XRP. As per the filing, the defendants remained until the end of truth discovery. More than 7 weeks after winning the SEC first interrogatory responses, they told the SEC they considered inadequate responses. The SEC then supplemented 5 of the issue's responses, gathered and conferred, and ordered defendants to identify what specific information they still require. The SEC has substantively explained the interrogatories at issue as demanded by the Federal Rules of Civil Procedure. In turn, the SEC also stated that Ripple's argument boiled down to the complaint that they were not satisfied with the answers they delivered. What's more, the SEC also declared that Ripple delayed complaints about the SEC interrogatory responses. This, despite it trying to provide additional details about the asked information. In any event, the SEC gave Ripple substantive answers to 12 of its requests for admission on the very topics Ripple presumably will apply to argue that its acquired a staking requirement was not sufficient. The SEC opposition did not rest well with the community, with many seeking the SEC not manifesting itself. As per the recent development in SEC litigation against Ripple, XRP holders serve their interests. This indicates that the community of XRP followers has stepped up to protect the altcoin from an adverse impact on its price. Ripple Holdings continue XRP's largest public holder in litigation on the payments giant. This has consistently led to a negative impression on native asset XRP's price since December 2020. John Deaton, founder of Crypto-Law.us and an influential XRP proponent, is convinced holders can now perform action. The community is granting a class action lawsuit in response to Deaton's call to action. After a flash crash's decline in the overall crypto market capitalization, the XRP price was retrieved through a spike in on-chain activity. As per the data from Santiment, XRP price surged 10% after a slight pullback as address activity intensified. Historically, an improvement in unique addresses is accompanied by a lift in price in short to mid-term. Further, optimistic developments in Ripple fuel the bullish narrative of XRP. The news of the Japanese financial giant's fund is again for Ripple and possible to improve the utility of the native asset XRP. Analysts have prophesied that XRP's price action will be defined by its behavior within a tight range, implying that the altcoin is expected to hit $1.60 soon. In a confrontation over documents in the U.S. Securities and Exchange Commission's epic clash with Ripple Labs Inc., the blockchain company's subjective great faith in selling more than $1.3 billion in XRP digital tokens led to be beside the point. Judge Sarah Net Byrne, the U.S. Magistrate of Manhattan, ordered on Sunday that Ripple did not disregard attorney-client privilege when it presented in March, in answer to the SEC complaint challenging the company of selling unregistered securities, that the SEC failed to give clear notification if XRP was subjected to federal securities rules. The ruling suggests Ripple does not have to turn over hundreds of privileged documents to the SEC. A few months ago, the Commission disputed in a letter brief to Net Byrne that Ripple's affirmative proper use defense had placed all of the company's legal guidance about XRP. The SEC already has possession of records composed by Ripple's outside counsel about whether XRP satisfies the U.S. Supreme Court test for security. Ripple provided those documents to the SEC during the Commission's years-long investigation of XRP sales before the SEC registered its complaint last December. But the SEC explained in its letter brief to Net Byrne that it must see hundreds of additional legal documents for which Ripple was still claiming privilege to expose the company's fair notice defense. Ripple, the SEC said, was well informed that XRP could be considered securities, as its counsel suggested in memos that the company shared with investors. By declaring that it did not receive fair notice, the SEC argued, the company had begun to inquire about its state of mind in trading XRP. And though its artfully drafted response to the SEC complaint did not explicitly mention the company's good faith, Ripple, they said, did not dispute in its affirmative defense that it had relied on its lawyers' counsel that it had worked in good faith. The company claimed that it was deprived of due process because the SEC sank for 8 years, as the market for XRP expanded, to clarify whether the digital tokens are secure. The relevant precedent, as per Ripple, was not Bilzerian but the Second Circuit's 1996 decision in Upton v. SEC. In that instance, the appeals court highlighted that Upton's fair notice defense was not based on his subjective view of his conduct but on his contention that the SEC declined to provide fair warning of the prohibited behavior to market partners. Ripple replied it's no accident that the SEC couldn't discover any cases in which courts held attorney-client privilege was declined by a defendant alleging an Upton-style fair notice defense. Ripple did not place its subjective state of mind or advice of counsel at issue simply by raising the defense. The state of mind of the SEC of whether XRP is security, not Ripple's, is a significant issue in the case. The magistrate judge earlier ordered the SEC to produce documents revealing its internal considerations on whether XRP, Bitcoin, and Ether are currencies or securities. Net Byrne was accurate in saying that her ruling is limited to whether Ripple suspended privilege by asserting a fair notice defense. It was not opening on the ultimate merits of the reason. The SEC questioned U.S. District Judge Annalisa Torres, supervising the case, to discover that defense entirely, claiming that it has provided plenty of notice to the cryptocurrency market via more than 70 enforcement actions against issuers. Ripple said in its response brief that the facts are so vigorously debated that the defense can't be settled on a motion to strike. Ripple General Counsel Stuart Alderoty stated in an email statement that he's pleased. The court made it evident that the proper focus of Ripple's defense that the SEC failed to give fair notice to the market is on the SEC, not on Ripple. The SEC is already aware of Ripple's outside legal advice about XRP, although the two sides bitterly differ in what those memos said. They've been disclosed in court filings but remain under seal. The SEC had told it required the rest of Ripple's privileged documents for upcoming depositions of company witnesses. After Net Byrne's ruling, the government seems to be limited to what it already has. Opinions represented here are those of the author. For 5 years, investors and project developers in the $2 trillion blockchain innovation space have been constrained to an increasingly annoying charade that the U.S. Securities and Exchange Commission, SEC, has called regulatory clarity. Years of SEC speeches, public statements, meeting records, correspondence, and first-hand accounts from market participants provide anything but clarity for the laws on digital assets or distributed ledger technology, DLT, projects. This is another financial crisis in the making. Other crypto companies have been lending products to customers who hold digital assets, and the only publicly listed exchange in the US wanted to do the same. The SEC acknowledged with subpoenas for records and depositions, required a list of all their clients who had expressed interest in the product and finally issued a warning of impending enforcement action. The US has experienced a fintech boom, but that doesn't intend to continue. The continued clarity charade is encouraging fintech innovators and investors abroad. The SEC is supposed to provide clear, unambiguous rules through a transparent process. Lack of clarity has created a financial crisis before, and it can occur again. One of the greatest challenges for traders and investors is whether or not to invest in XRP. It is far more affordable than most other cryptocurrencies in the overall crypto market at its current rate. This makes it convenient to buy for many investors and suitable for mass adoption and informational purposes. The advantages it seems to offer, such as the speed of transactions and low charges, would make it seem like a good investment with more potential for institutional backing and developments soon. If you want to continue knowing about XRP, we have 2 more videos waiting for you on the end screen to check out. Make sure to subscribe and give us a thumbs up. Thank you so much for watching. See you in the next video. Kindly note that prices of cryptocurrencies frequently change, so by the time you watch this video, it might have changed to a whole new value. The information provided in this video does not constitute investment advice, financial advice, trading advice, or any other sort of advice. It would help if you did not treat any of the content as such. The content in this video is for educational purposes only and hence should not be considered as financial advice. Do conduct your own due diligence and consult your financial advisor before making any investment decisions.